The term political science is intimately related to the word politics, which itself is derived from the Greek word polisal, means a situestate thegenera form of political organization in ancient Greece. The sophists, the wandering teacher of wisdom, particularly Protagoras and Gorgias in Athens, were the first to expound a political theory. Later on, Socrates, Plato and Aristotle continued to conduct the scientific study of the various problems concerning the state and the government. Aristotle, the world-famous Greek philosopher, however, excelled his teacher Plato and his teacher's teacher Socrates. Now Aristotle is regarded as the father of the science of politics in the West, while Manu is considered to be the first political thinker of men. His famous book, Manusmriti, is regarded as the first book of law in India. Later on it was Kautilya, Chanakya, who formed and formulated thinking and gave it a concrete form in the shape of a book named Arthashastra, a well-known book of Indian polity. In his famous book, Politics, Aristotle has asserted, man is by nature a political animal, and he who by nature and not by mere accident is without state, either above humanity or below it. Republic of India. India, a union of states, is a sovereign socialist secular democratic republic with a parliamentary system of government. The republic is governed in terms of the constitution, which was adopted by Constituent Assembly on 26 November 1949 and came into force on 26 January 1950. The constitution, which envisages parliamentary form of government, is federal in structure with unitary features. The President of India is the constitutional head of executive of the Union. Article 74(1) of the Constitution provides that there shall be a council of ministers with the Prime Minister as its head to aid and advise the President, who shall in exercise of his functions act in accordance with such advice. The real executive power thus vests in the Council of Ministers with the Prime Minister as its head. The Council of Ministers is collectively responsible to the House of the People, Lok Sabha. Similarly, in states, the governor is the head of executive, but it is the Council of Ministers with the Chief Minister as its head in whom real executive power vests. The Council of Ministers of a state is collectively responsible to the Legislative Assembly of the state. The Constitution distributes legislative power between Parliament and state legislatures and provides for vesting of residual powers in Parliament. The power to amend the Constitution also vests in Parliament. 606. Government of India. Description: Panicolors. Country name: Republic of India. Bharat Ganab. Government times: type: sovereign socialist secular democratic republic with a parliamentary system of government. Capital: administrative divisions: New Delhi. 28 states and union territories. Independence: 15th August 1947. Arom, the British colonial rule. Constitution. The Constitution of India came into force on 26 January 1920. Legal system. The Constitution of India is the fountain source of the legal system in the country. Executive branch. The President of India is the head of the state, while the Prime Minister is the head of the government and runs office with the support of the Council of Ministers, who form the Cabinet Ministry. Legislative branch. The Indian legislature comprises of the Lok Sabha, House of the People, and the Rajya Sabha. Council of States termines both the houses of the Parliament. Judicial branch. The Supreme Court of India is the apex body of the Indian legal system, followed by other high courts and subordinate courts. Flag description. The national flag is a horizontal tricolor of deep saffron, Kesrial at tip, white in the middle and dark green at the bottom in equal proportion. At the center of the Ireland is a navy blue wheel, which is a representation of the Ashoka Chakra at Sarnath National Days. 26th January, Republic Day. 15th August, Independence Day. 2 October, Gandhi Jayanti. Mahatma Gandhi's birthday. Source: india.gov.in. Constitution. Constitution is the foundational law of a country which ordains the fundamental principles on which the government for the governance of that country is based. It lays down the framework and principal functions of various organs of the government as well as the modalities of interaction between the government and its citizens. With the exception of the United Kingdom, 0.k, almost all democratic countries possess a written constitution. India also possesses an elaborate written constitution which was enacted by a constituent assembly specifically set up for the purpose. 1. Evolution of Indian Constitution. Our constitution, our present constitution, the first constitution of India framed and given to themselves by the people of India, was adopted by the Constituent Assembly on 25 November 1929. It came into full operation with effect from 26 January 1950. The constitution as originally adopted had 22 parts, 395 articles and 8 schedules. Its present text is as amended from time to time. 607. Although the systems of Anjagot India do have their reflections in the Constitution of India, the direct sources of the Constitution lie in the administrative and legislative developments of the British period. Akundis and chronological description of acts, documents and eventica culminate in the framing of tus juris. Written commutation is given here. Administrative and legislative reforms. Fee for 1857. Regulating Act of 1773. This act was based on the report of a committee headed by the British Prime Minister Lord North. Governance of the East India Company was put under British parliamentary control. The Governor of Bengal was nominated as Governor General for all the 3 presidencies of Calcutta, Bombay and Madras. Warren Hastings was the first such Governor General. Under this Act, a Supreme Court was established in Calcutta, now Kolkata. In 14, Sir Elijah Imp was the first Chief Justice. Others judges were 1 Chambers, 2 Lyminster and Hyde. Governor General was empowered to make rules, regulations and ordinances with the consent of the Supreme Court. Pitts India Act of 1784. It was enacted to improve upon the provisions of Regulating Act of 1773 to bring about better discipline in the company's system of administration. A 6-member board of controllers was set up which was headed by a minister of the British government. All political responsibilities were given to this board. Trade and commerce-related issues were under the purview of the court of directors of the company. Provinces had to follow the instructions of the central government, and Governor-General was empowered to dismiss the failing Provincial Government Charter Act of 1793. Main provisions of the previous acts were consolidated in this act. Provided for the payment of salaries of the members of the Board of Controllers from Indian revenue courts, were given the power to interpret rules and regulations. Charter Act of 1813. Trade monopoly of the East India Company came to an end. Powers of the three councils of Madras, Bombay and Calcutta were enlarged. They were also subjected to greater control of the British Parliament. The Christian missionaries were allowed to spread their religion in India. Local autonomous bodies were empowered to levy taxes. Charter Act of 1833. The Charter Act 1833, which was enacted by the British Parliament, provided for the establishment of a Lave Commission for consortium and codification of Indian laws. 609. In 1835, Lord Macaulay was appointed as chairman of the first Law Commission. Sir James Stephen was appointed as a law member in place of Lord Macaulay. Slavery system in India was declared illegal through this Charter Act and was abolished in 1843. The Governor-General and his council were given powers. This council could legislate for the whole India subject to the approval of the Board of Control, and the council got full powers regarding revenue, and a single budget for the country was prepared by its Governor-General. The East India Company was reduced to administrative and political entity, and several lords and ministers were nominated as ex officio member of the Board of Controllers. For the first time, the Governor-General's government was known as the Government of India and his count as the Indian Council. Charter Act of 1853. This was the last of the Charter Acts, and it made important changes in the system of Indian legislation. This act followed a report of the then Governor-General Dalhousie for improving the administration of the company. A separate governor for Bengal was to be appointed. Legislative and administrative functions of the council were separately identified. Recruitment of the company's employees was to be done through competitive exams. British Parliament was empowered to put company governance of India to an end at any suitable time. Administrative and legislative reforms after 1857. Government of India Act 1858. British Crown decided to assume sovereignty over India from the East India Company in an apparent consequence of the revolt of 1857, described as an armed sepoy mutiny by the British historians and remembered as the first war of independence by the Indians. The first statute for the governance of India under the direct rule of the British government was the Government of India Act 1958. It provided for absolute British imperial control over India without any popular participation in the administration of the country. The powers of the Crown were to be exercised by the Secretary of State for India, assisted by a council of 15 members, known as the Council of India. The country was divided into provinces headed a governor or lieutenant governor aided by his executive council. The provincial governments had to function under the superintendence, direction and control of the Governor-General in all matters. All the authority for the governance of India vested in the Governor-General in council, who responsible to the Secretary of State. The Secretary of State was ultimately responsible the British Parliament. The 611. Indian Councils Act 1861. Indian Polity. This is an important landmark in the constitutional history of India. By this act, the powers of the Crown were to be exercised by the Secretary of State for India, assisted by a council of 15 members, known as the Council of India. The Secretary of State, who was responsible to the British Parliament, governed India through the Governor-General, assisted by an executive council. This act enabled the Governor-General to associate representatives of the Indian people with the work of legislation by nominating them to his expanded council. This act provided that the Governor-General's executive council should include certain additional non-official members also while transacting legislative business as a legislative council. But this legislative council was neither representative nor deliberative in any sense. It decentralized the legislative powers of the Governor-General's council and vested them in the governments of Bombay and Madras. Indian Councils Act 1892. The non-official members of the Indian Legislative Council were to be nominated by the Bengal Chamber of Commerce and the provincial legislative councils, while the non-official members of the provincial councils were to be nominated by certain local bodies such as universities, district boards, municipalities, zemindars, etc. The councils were to have the power of discussing the budget and addressing questions to the executive. Morley II reforms and the Indian Councils Act 1909 reforms recommended by the then Secretary of State for India, Lord Morley, and the Viceroy, Lord Minto, were implemented by the Indian Councils Act 1909. The maximum number of additional members of the Indian Legislative Council, Governor-General's Council, was raised from 16, under the Act of 1892, to 60, excluding the executive councillors. It provided, for the first time, for the association of Indians with the executive councils of Viceroy and governors. Satyendra Prasad Sinha became the first Indian to join the Viceroy's executive council. He was appointed as the law member. It also provided for the separate representation of presidency corporations, chambers of commerce, universities, zemindars, Sikhs, Indian Christians, Anglo-Indians and Europeans. The size of provincial legislative councils was enlarged by including elected non-official members so that the official majority was gone. An element of election was also introduced in the legislative council at the centre also, but here the official majority was maintained. The legislative councils were empowered to move resolutions on the budget and on any matter of public interest, except certain specified subjects, such as the armed forces, foreign affairs and the Indian states. It provided, for the first time, for separate representation of the Muslim community, and thus the act legalized communalism, and Lord Minto came to be known as the father of communal electorate. 611. Constitution. The Government of India Act, 1915. This was passed to consolidate the provisions of the preceding Government of India Acts, Montagu-Chelmsford Reforms, and the Government of India Act, 1919. The then Secretary of State for India Mr. E.S. Montag and the Governor-General Lord Chelmsford formulated proposals for the Government of India Act, 1919. It created a new office of the High Commissioner for India in London and transferred to him some of the functions hitherto performed by the Secretary of State for India. It provided for the establishment of a Public Service Commission. Hence, a Central Public Service Commission was set up in 1926 for recruiting civil servants. Responsible government in the provinces was to be introduced, without impairing the responsibility of the Governor, through the Governor-General, for the administration of the province, by resorting to device known as diarchy or dual government. This act provided voting right to the Indian women. For the first time, David Lloyd George was the then Prime Minister of England. The subjects of administration were to be divided into two categories: central and provincial. Central subjects were those which were exclusively kept under the control of the central government. The provincial subjects were subdivided into transferred and reserved subjects. The transferred subjects were to be administered by the governor with the aid of ministers responsible to the Legislative Council, in which the proportion of elected members was raised to 70%. Number 11A. The reserved subjects were to be administered by the governor and his executive council with no responsibility to the legislature. The previous central control over the provinces in administrative, legislative and financial matters was relaxed. Sources of revenue were divided into two categories so that the provinces could run the administration with the revenue raised by the provinces themselves. The provincial budget was separated from the central budget. The provincial legislature was empowered to present its own budget and levy its own taxes relating to the provincial sources of revenue. The central legislature retained power to legislate for the whole country on any subject. The control of the Governor-General over provincial legislation was retained by providing that a provincial bill, even though assented to by the Governor, would become law on to when assented to also by the Governor-General. The Governor was empowered to reserve a bill for the consideration of the Governor-General if it was related to some specified matters. The Governor-General in Council continued to remain responsible only to the British Parliament through the Secretary of State for India. 614. The Indian legislature was made more representative and, for the first time, bicameral. Lionel Curtis was a British official and author. His ideas concerning diarchy were important in development of the Government of India Act, 1919, and his writing influenced the evolution of the Commonwealth of Nations. State this: the upper house was named the Council of was composed of 60 members, of whom 34 were elected. The lower house was named the Legislative Assembly. This was composed of about 144 members, of whom 104 were elected. The electorates were arranged on a communal and sectional basis, developing the Moleman to devise further. The Governor-General's overriding powers in respect of central legislation were retained as follows: A. His prior sanction was required to introduce bills relating to certain matters. B. He had the power to veto or reserve for consideration of the Crown any bill passed by the Indian legislature. C. He had the converse power of certifying bill or any grant refused by the legislature. D. He could make ordinances in case of emergency. Simon Commission. This commission, headed by Sir John Simon, constituted in 1927 to inquire into the working of the Act of 1919, placed its report in 1930. The report was examined by the British Parliament and the Government of India Bill was drafted accordingly. The Government of India Act, 1935. It was a lengthy and detailed document having 321 sections and 10 schedules. The Act of 1935 prescribed a federation taking the provinces and the Indian states, native states, as units. It was optional for the Indian states to join the federation, and since they never joined, the federation never came into being. The Act separated Burma from India and two new provinces of Orissa and Sindh were created. The Act divided legislative powers between the centre and provinces. The executive authority of a province was also exercised by a governor on behalf of the Crown and not as a subordinate of the Governor-General. The governor was required to act with the advice of ministers responsible to the legislature in certain matters. The governor was required to act in his discretion, without ministerial advice and under the control and directions of the Governor-General and through him, of the Secretary of State. The executive authority of the centre was vested in the Governor-General, on behalf of the Crown. Councillors or council of ministers responsible to the legislature was not appointed, although such provisions existed in the Act of 1935. The central legislature was bicameral, consisting of the Federal Assembly and the Council of State. 616. Legislate in 6 provinces. The legislature was bicameral, comprising a legislative assembly and a council in other provinces. The legislature was apart from the Governor-General's power of veto. Bill passed by the central legislature was also sub to veto by the Crown. The Governor-General could prevent discussion in the legislature and suspend the proceedings on any bill if he was satisfied that it would affect the discharge his special responsibilities. The Governor-General had independent powers. A legislation, concurrently with those of the legislature on some subjects, no bill or amendment could be introduced in the legislature without the Governor-General's previous sanction. A threefold division in the Act of 1935. There was a federal list over which the federal legislature had exclusive powers of legislation. There was a province list of matters over which the provincial legislature had exclusive jurisdiction. There was a concurrent list also over which both the federal and provincial legislature had competence. The Governor-General was empowered to authorize either the federal or the provincial legislature to enact a law with respect to any matter which was not enumerated in the above noted legislative lists. Dominion status, which was promised by the Simon Commission in 1929, was not conferred by the Government of India Act, 1935. Cripps Mission. In March 1942, Sir Stafford Cripps, a member of the British Cabinet, came with a draft declaration on the proposals of the British government. These proposals were to be adopted at the end of the Second World War provided the Congress and the Muslim League could accept them. According to the proposals, the Constitution of India was to be framed by an elected Constituent Assembly by the Indian people. The Constitution should give India dominion status. There should be one Indian Union comprising all the provinces and Indian states. Any province or Indian state not accepting the Constitution would be free to retain its constitutional position existing at that time, and with such no acceding provinces the British government could enter into separate constitutional arrangements. Cabinet Mission Plan. In March 1946, Lord Attey sent a cabinet mission India consisting of 3 cabinet ministers, named Lord Pethick Lawrence, Sir Stafford Cripps and Mr. A.V. Alexander. The object of the mission was to help India achieve its independence as early as possible, and to set up Constituent Assembly. The cabinet mission rejected the claim for a separate Constituent Assembly and a separate state for the Muslim. 618. According to Cabinet Mission Plan, there was to be a Union of India, comprising both British India and the states and having jurisdiction over the subjects of foreign affairs, defence and communication. All residuary powers were to be vested in the provinces and the states. The Union was to have an executive and a legislature consisting of representatives of the provinces and the states. Any decision involving a major communal issue in the legislature was to require a majority support of representatives of each of the 2 major communities present and voting, as well as a majority of all the members present and voting. The provinces could form groups with executives and legislatures, and each group could be competent to determine the provincial subjects. The Mountbatten Plan. The plan for transfer of power to the Indians and partition of the country was laid down in the Mountbatten Plan. I was given a formal shape by a statement made by the British government on 3 June 1947, the Indian Independence Act, 1947 of the British Parliament. In pursuance of this Act, the Government of India Act, 1915 was amended by the adaptation orders, both in India and Pakistan, for setting up an interim Constituent Assembly to draw up the future constitution of the country. Interim Government, 2 September 1946, as per the proposal of Cabinet Mission in 1945, members' portfolios held. Jawaharlal Nehru, Vice President of State Council, External Affairs and Commonwealth Relations, to Sardar Vallabhbhai Patel, Home, Information and Broadcasting Dr. Rajendra Prasad, Food and Agriculture Dr. John Mathai, Industries and Supplies Jagavan Ram. Labor Sardar Baldev Singh, Defence 7 Ch. Baba, Works, Mines and Power Liaquat Ali Khan, Finance 9 Abdur Rabnishter, Posts and Air Railways and Transport 11 C. Rajgopalachari, Education and Arts, Commerce Chajamfar Ali Khan, 14 Joginder Nath Mandal, Law, Health. First Cabinet of Independent India, 1947, members' portfolios held. Jawaharlal Nehru, Prime Minister, External Affairs and Commonwealth Relations, Scientific Research, to Sardar Vallabhbhai Patel, Home, Information and Broadcasting, States, Dr. Rajendra Prasad, Maulana Abul Kalam Azad, Food and Agriculture, Education, Dr. John Mathai, Railways and Transport, R.K. Shanmugam Chetkar, Finance, 618, members' portfolios held. Dr. B.R. Ambedkar, Law, 8, Jagjeevan Ram, Labor, 9, Sardar Baldev Singh, Defence, 10, Raj Kumar Amrit Kaur, Health, 11, C.H. Baba, Commerce, 12, Ran Ahmed Kidwai, Communication, 13, Dr. Shyama Prasad Mukherjee, Industries and Supplies, 14, V. N. Gargil, Work, Mines and Power. From the 15th August 1947, India ceased to be a dependency, and the suzerainty of the British Crown over the Indian states and the treaty relations with tribal areas lapsed from that date. In a referendum held on 6 July 1947, Sylhet, Assam, had decided to join the province of East Bengal, to be a part of a new country, Pakistan. The office of the Secretary of State for India was abolished. The Governor-General and the governors lost extraordinary powers of legislations to compete with the legislature. The Central Legislature of India, composed of the Legislative Assembly and the Council of States, ceased to exist on 14 August 1947. The Constituent Assembly itself was to function also as the Central Legislature with complete sovereignty. To Constituent Assembly and making of the Constitution, the Cabinet Mission envisaged the establishment of a Constituent Assembly to frame a constitution for the country. Members of the Constituent Assembly were elected by the provincial legislative assemblies. Each province and each Indian state were allotted seats, in proportion of its population, roughly in the ratio of 1 to a million. The seats so ascertained were distributed among the main communities in each province. The main communities recognized were Sikh, Muslim and general. Important committees of the Constituent Assembly and their chairman. Name of the committee: Chairman 1. Committee on the Rules of Procedure, Dr. Rajendra Prasad. 2. Steering Committee 3. Finance and Staff Committee 4. Ad Hoc Committee on the National Flag P.T. Jawaharlal. 5. Union Constitution Committee Nehru. 6. Union Powers Committee 7. States Committee Sardar Vallabhbhai. Advisory Committee on Fundamental Patel Rights, Minorities and Tribal and Excluded Areas 9. Drafting Committee Dr. B.R. Ambedkar. 10. Credential Committee Alladi Krishnaswamy Iyer. 11. House Committee B. Patade. C. Taramaya. 12. Order of Business Committee Kilometer. Munshi 620, Lucent's Gen Chalman name of the F. Mavlankar 13 Committee on the Fundians of the Constituent Assembly H.C. Mukherjee 14. Minorities Subcommittee Kripalini 15 Fundamental Rights Subcommittee Northeast Frontier Tribal Areas and Gopinath Bandele Assam excluded and partially excluded Aras Subcommittee 17. Excluded and partially excluded Area AV Thakkar. Other than Tozainame My Subcommittee. The total number of members of the Constituent Assembly were to be 389 of whom were representatives from the Indian states, princely states, and 296 from the British India tot which 292 from the governors provinces and 1 each from chief commissioners, provinces. After the partition of India, number of members of the Constituent Assembly came to 297, of whom 284 were actually present on the 26th November 1919 and signed on the finally approved Constitution of India. The Constituent Assembly, which had been elected for undivided India, held its first meeting on December 9 to 1946 and reassembled on 14 August 1947 as the Sovereign Constituent Assembly for the Dominion of India. Elephant was adopted as the symbol, seal, of the Constituent Assembly. It took 2 years, 11 months and 18 days for the Constituent Assembly to finalize the Constitution. Objective resolution was moved in the first session of the Constituent Assembly, on December 13, 1916, by P.T. Jawaharlal Nehru, which was adopted after considerable deliberation and debate in the Assembly on 22 January 194. The following objectives were embodied in the resolution. To foster unity of the nation and to ensure its economic and political security, to have a written constitution and to proclaim India as a sovereign democratic republic. To have a federal form of government with the distribution of powers between the center and states. To guarantee and secure justice, equality, freedom of thought, expression, belief, faith, worship, vocation, association and action to all the people of India. To provide adequate safeguards for minorities, backward and tribal areas and depressed and other backward classes. To maintain the integrity of the territory of the Republic and its sovereign rights on land, sea and air according to justice and the law of civilized nations. To attain rightful and secured place in the world and make its full and willing contribution to the promotion of the world peace and the welfare of mankind. The principles of the Constitution were outlined by various committees of the Assembly, and there was a general discussion on the reports of these committees. The Constituent Assembly appointed the drafting committee with Dr. B.R. Ambedkar as the chairman on 29 August 1947 to scrutinize the draft of the text of the Constitution of India prepared by the Constitutional Advisor B.N. Ras, Benegal Nursing Rao. 621. The drafting committee, headed by Dr. B.R. Ambedkar, submitted a draft Constitution of India to the President of the Assembly on 21 February 1948. The members of drafting committee were N. Gopalaswamy Iyengar, Alladi Krishnaswamy Iyer, Dr. K. M. Munshi, Syed Muhammad Sadullah B. L. Mitter, later replaced by N. Madhavar Rao, Dr. D.P. Ketan, replaced on death in 1948 by T.T. Krishnamachari. The third and final reading of the draft was completed on 26 November 1949. On this date, the signature of the President of the Assembly was appended to it and the Constitution was declared as passed. The provisions relating to citizenship, elections and provisional parliament etc. were implemented with immediate effect, that is from the 26th November 2019. The rest of the provisions of the Constitution came in force on 26th January 1950 and this date is referred to in the Constitution as the date of its commencement. 26th November is observed as Constitution Day to celebrate the 125th birth anniversary of Dr. B.R. Ambedkar. The Government of India Ministry Social Justice and Empowerment decided to observe Constitution Day on 26th November W.F. 2015. 3 different sources of Indian Constitution. The skeleton of the Constitution was derived from the Government of India Act 1935, though many provisions were imported from other constitutions of the world. OU of 395 articles of the Constitution of India. The text of almost 250 articles are taken from Gov. of India Act 1935 directly or with some modifications. Some of them are listed below along with the Government of India Act 1935, Government of India Act 1935. This act formed the basic premise or the basis or blueprint of the Constitution of India with the features of federal system, office of governor, emergency powers etc. Besides, the Constitution of India borrowed from the Constitution of Britain, law-making procedures, rule of law, single citizenship, bicameral parliamentary system, office of CAG. Constitution of USA, independence of judiciary. Judicial review, fundamental rights, removal of Supreme Court and High Court judges, preamble and functions of President and Vice President. Constitution of Canada, federation with strong centre, to provide residuary powers to the centre, Supreme Court's advisory jurisdiction. Constitution of Ireland, directive principles of star policy, method of presidential elections and the nomination of members to Rajya Sabha by the President. Weimar Constitution of Germany provisions concerning the suspension of fundamental rights during emergency. Constitution of Australia, idea of the concurrent trade and commerce provisions. Constitution of South Africa, amendment with 2 majority in parliament and election of the members of Rajya Sabha on the basis of proportional representation. Constitution of France, republican system, principle of liberty, equality and fraternity. Constitution of former USSR, fundamental duty, ideals of justice in preamble. 623, 4. Important parts, articles of the Constitution. Articles subject art. 1 to 4 art. 5 to 11 Part 1 the Union and its territory. Part 11 Citizenship. Part IU. Fundamental rights art. 12 Definition art. 13 laws inconsistent with or in derogation of the fundamental rights right to equality art. 14 equality before law art. 15 prohibition of discrimination on grounds of religion, race, caste, sex or place of birth art. 16 equality of opportunity in matters of public employment art. 17 abolition of untouchability art. 18 abolition of titles right to freedom art. 19 protection of certain rights regarding freedom of speech etc. art. 20 protection in respect of conviction for offences art. 21 protection of life and personal liberty art. 21 a right to education art. 22 protection against arrest and detention in certain cases. Right against exploitation art. 23 prohibition of traffic in human beings and forced labor art. 24 prohibition of employment of children in factories etc. Right to freedom of religion art. 25 freedom of conscience and free profession, practice and propagation of religion art. 26 freedom to manage religious affairs art. 27 freedom as to payment of taxes for promotion of any particular religion art. 28 freedom as to attendance at religious instruction or religious worship in certain educational institutions cultural and educational rights art. 29 protection of interests of minorities art. 30 right of minorities to establish and administer educational institutions saving of certain laws art. 31 a saving of laws providing for acquisition of estates etc. art. 318 validation of certain acts and regulations art. 31c saving of laws giving effect to certain directive principles right to constitutional remedies art. 32 remedies for enforcement of rights conferred by this part art. 33 power of parliament to modify the rights conferred by this part in their application to forces etc. 623 art. 34 restriction on rights conferred by this part while martial law is in force in any area art. 35 legislation to give effect to the provisions of this part 4 directive principles of state policy art. 36 definition art. 37 application of the principles contained in this part art. 38 state to secure a social order for the promotion of welfare of the people art. 39 certain principles of policy to be followed by the state art. 39 equal justice and free legal aid art. 40 organization of village panchayats parts of Indian Constitution part article. Provisions preamble 1 to 4 the Union and its territory 11.5 to 11 citizenship 12 to 35 fundamental rights 436 to 51 directive principles of state policy IVA 51 a fundamental duties V 52 to 151 the Union 6 152 to 237. The states 7 238 the states in part B of the first schedule 8 239 to 242 the union territories 9 243 to 243 to 0 the panchayats 9 A 243 P to 2432 G the municipalities 9 B 243 ZH to 243 ZT the cooperative societies 244 to 244 other scheduled and tribal areas 11 245 to 263 relations between the union and the states. 11 264 to 300 of finance, property contracts and suits 13 301 to 307 trade, commerce and intercourse within the territory of India 14 308 to 323 services under the Union and the states NIVA 323 A to 323 B tribunals 15 324 to 329 A elections 16 330 to 342 special provisions relating to certain classes 17 343 to 351 official language 18 352 to 360 emergency provisions 19 361 to 367 miscellaneous XX 368 amendment of the Constitution 21 369 to 392 temporary transitional and special provisions 22 393 to 395 short title commencement authoritative text in Hindi and repeals art. 41 right to work, to education and to public assistance in certain cases art. 42 provision for just and humane conditions of work and maternity relief art. 43 living wage etc. for workers art. 4.3 a participation of workers in management of industries art. 4.3b the state shall endeavour to promote voluntary formation, autonomous functioning, democratic control and professional management of cooperative societies. 624 art. 41 uniform civil code for the sector art. 45 provision for early childhood care and education to children below the age of 6 scan art. 4 promotion of educational and economic interest of scheduled castes scout tribes and vacations art. 47 duty of the state to raise the level of nutrition and the standard of living and to improve pubis health art. 48 organization of agriculture and animal husbandry art. 48 a protection and improvement of environment and safeguarding of forests and wildlife art. 49 protection of monuments and places and objects of national importance art. 50 separation of judiciary from executive art. 51 promotion of international peace and security part IVA art. 51 a fundamental duties part V the Union chapter 1 the executive art. 52 the President of India art. 53 executive power of the Union art. 54 election of President art. 61 procedure for impeachment of the President art. 63 the Vice President of India art. 64 the Vice President to be ex officio chairman of the Council of States art. 65 the Vice President to act as President or to discharge his functions during casual vacancies in the office or during the absence of President art. 66 election of Vice President art. 72 power of President to grant pardons etc. and to suspend, remit or commute sentences in certain cases art. 74 Council of Ministers to aid and advise President art. 76 Attorney General for India Chapter 2, Parliament Art 79 Constitution of Parliament. Art 80 Composition of the Council of States, Rajya Sabha, Art 81 Composition of the House, Lok Sabha, of the People Art 83 Duration of Houses of Parliament Art 84 Qualification for Membership of Parliament Art 85 Sessions of Parliament, Prorogation and Dissolution Art 86 Right of President to address and send messages to Houses Art 87 Special Address by the President Art 88 Rights of Ministers and Attorney General as respects Houses Art 89 The Chairman and Deputy Chairman of the Council of States Art 90 Vacation and resignation of and removal from the office of Deputy Chairman Art 93 The Speaker and Deputy Speaker of the House of the People 626 Art 44 Vacation and resignation of and removal from the offices of Speaker and Deputy Speaker. Power of the Deputy Speaker or other persons perform the duties of the office of or to act. Art 95 Art 98 Speaker Secretariat of Parliament oath or affirmation by members. Art 99 Voting in Houses, power of Houses to and notwithstanding vacancies and quorum. Art 100 Art 105 Powers, privileges etc. of the Houses of Parliament and of the members and committees thereof. Art 108 Art 106 Salaries and allowances of members. Art 107 Provisions as to introduction and passing of bill joint sitting of both houses in certain cases. Art 109 Special procedure in respect of money bills. Art 110 Definition of money bills. Art 111 Assent to bills. Art 112 Art 113 Annual financial statement, budget. Procedure in Parliament with respect to estimates. Art 114 Appropriation bills. Art 115 Supplementary, additional or excess grants. Art 116 Votes on account, votes of credit and exceptional grants. Art 117 Special provisions as to financial bills. Art 1187 Rules of procedure. Art 119 Regulation by law of procedure in Parliament in relation to financial business. Art 120 Language to be used in Parliament. Art 121 Restriction on discussion in Parliament. Art 122 Courts not to inquire into proceedings of Parliament. Chapter 3, Legislative powers of the President. Art 123 Power of President to promulgate ordinances during recess of Parliament. Chapter 4, The Union Judiciary. Art 124 Establishment and Constitution of Supreme Court. Art 125 Salaries etc. of Judges. Art 126 Appointment of Acting Chief Justice in the Supreme Court. Art 127 Appointment of ad hoc judges in the Supreme Court. Art 128 Attendance of retired judge at sittings of the Supreme Court. Art 129 Supreme Court to be a court of record. Art 130 Seat of Supreme Court. Art 131 Original jurisdiction of Supreme Court. Art 132 Appellate jurisdiction of Supreme Court appeals from High Court in certain cases. Art 133 Appellate jurisdiction of Supreme Court appeals from High Court in regard to C matters. Appellate jurisdiction of Supreme Court regard to criminal matters. Art 134 Art 134 A certificate for appeal to the Supreme Court 627 and 11 Jurisdiction and powers of the Federal Court under existing law to be exercisable by the Supreme Court. Art 136 Special leave to appeal by the Supreme Court. Art 137 Review of judgments or orders by the Supreme Court and 138 Enlargement of the jurisdiction of the Supreme Court and 141 Law declared by Supreme Court to be binding on all courts. Art 143 Power of President to consult Supreme Court and 144 Civil and judicial authorities to act in aid of the Supreme Court. Lokpal. A Lokpal is an ombudsman in India. It has jurisdiction over at members of Parliament, MPs, the Prime Minister, with certain exceptions, ministers and all civil servants etc. In case of corruption, Lokpal is empowered to sanction prosecution. The amended Lokpal and Lokayukta Bill 2011 was passed by Rajya Sabha and Lok Sabha on 17th and 18th December 2013 respectively. Samajwadi Party opposed the bill. A high-level selection committee led by the Prime Minister had recommended the appointments for chairperson and members of the Lokpal. The President approved the appointments. President Ramnath Kovind had on the 23rd March 2019 administered the oath of office to Justice Pinaki Chandra Gose as the country's first Lokpal. Justice Gose, 66, retired as Supreme Court judge in May 2017. He last served as member of the National Human Rights Commission, NHRC. All 8 newly appointed members of Anti-Corruption Ombudsman Lokpal on the 27th March 2019 took oath of office. They were administered the oath by Lokpal Chairperson Justice Pinaki Chandra Gose, the former Chief Justices of different High Courts Justices Dilip B. Bhosale, Pradeep Kumar Mohanty, Abhilasha Kumari and Ajay Kumar Tripathi took oath as judicial members in the Lokpal. Former First Woman Chief of Sashastra Seema Bal, SSB, Archana Ramasundaram, ex-Maharashtra Chief Secretary Dinesh Kumar Jain, former IRS Officer Mahendra Singh and Gujarat Cadre ex-LAS Officer Indrajit Prasad Gautam were sworn in as the Lokpal's non-judicial members. Lokayukta. The institution of Ombudsman is typically Scandinavian. The office of Ombudsman has been in existence since 1809 in Sweden, also in Finland, since 1919, Denmark, 1955, Norway and New Zealand, 1962. Maharashtra is the first state in India to introduce the concept of Lokayukta and UPA Lokayuktas Act 1971 in view of the recommendations made by the Administrative Reforms Commission headed by Morarji Desai in 1966. Being the Maharashtra Lokayukta institution came into from 25th October 1972. Chapter V, Controller and Auditor General of India. Controller and Auditor General of India. Art. 149 Duties and Powers of the Controller and Art. 148 Auditor General. 628, Part 6, The States. Art. 152 to 237 The government at the state level, the executive, the state legislature, the high courts and subordinate courts. Part 7 Art. 238 The states in Part B of the first schedule. Part 8 Art. 239 to 241 The union territories. Part 9 Art. 243 to 243 to 0 The panchayats. Part IXA Art. 243-P to 243-ZC The municipalities under Article 2432D The district planning committee is constituted. According to Article 243, Z, the maximum number of directors of a cooperative society may be 21. Part IXB Art. 243ZH to 243-2T The cooperative societies. Part X Art. 244-244A The scheduled and tribal areas. Part 11 Art. 245 to 263 Relations between the union and the states. Part 12 Art. 264 to 300 Finance, Property Contracts and Suits, Distribution of Revenue between Union and States, Finance Commission, Borrowing Property Contracts, Rights, Liabilities, Obligations and Suits. Art. 268 Taxes are levied and collected by the centre but distributed between the centre and the states. Art. 300 A right to property. Part 13, Art. 301 to 307 Trade, Commerce and Intercourse within India. Part 14 Services under the Union and the States. Art. 309 Recruitment and Conditions of Service of Persons serving the Union or a State. Art. 310 Tenure of Office of Persons serving the Union or a State. Art. 311 Dismissal, Removal or Reduction in Rank of Persons employed in civil capacities under the Union or a State. Art. 312 All India Services. Art. 315 Public Service Commissions for the Union and for the States. Art. 316 Appointment and Term of Office of Members. Art. 317 Removal and Suspension of a Member of a Public Service Commission. Art. 318 Power to make regulations as to conditions of service of members and staff of the Commission. Art. 320 Functions of Public Service Commissions. Art. 321 Power to extend functions Commissions of Public Service. Art. 323 Reports of Public Service Commissions. Part 3 Art. 323A 3238 Tribunals. Part 15 Elections. Art. 324 Superintendent's direction and control of elections to be vested in an election commission. Art. 325 Number person to be ineligible for inclusion in, or to claim to be included in a special, electoral roll on grounds of religion, race, caste or sex. Art. 326 Elections to the House of the People and to the Legislative Assemblies of States to be on the basis of adult suffrage. 171 629. Art. 327 Power of Parliament to make provision with respect to elections to legislatum. Art. 128 Power of Legislature of a state to make provision with respect to elections to such legislature. Art. 329 Bar to interference by courts in electoral matters. Part 16 and 310 to 12 Bodil provisions for certain. Part 17 Art. 351 Official Language. Art. 352 to 360 Emergency provisions. Part 18 Art. 352 Proclamation of Emergent and 360 Proclamation of Financial Emergency. Part 19 Miscellaneous. Art. 361 A protection of publication of proceedings of Parliament and state legislatures. Art. 363 Bar to interference by courts in disputes arising out of certain treaties, agreements, etc. Art. 363 A recognition granted to rulers of Indian states to seize and privy purses to be abolished. Art. 364 Special provisions as to major ports and aerodromes. Art. 365 Effect of failure to comply with, or to give effect to, directions given by the Union. Part XX. Art. 368 Amendment of the Constitution. Part 21, Art. 360 to 392 Temporary transitional and special provisions. Special status of states in exercise of the powers conferred by Clause 3 of Article Declaration under Article 370, 370 read with Clause 1 of Article 370 of the Constitution of India. The President on the recommendation of Parliament is pleased to declare that, as from the 5th August 2019, all clauses of the said Article 370 shall cease to be operative except the following, which shall read as under. Namely 370. All provisions of this Constitution, as amended from time to time, without any modifications or exceptions, shall apply to the state of Jammu and Kashmir, notwithstanding anything contrary contained in Article 152 or Article 308 or any other article of this Constitution or any other provision of the Constitution of Jammu and Kashmir or any law, document, judgment, ordinance, order, by-law, rule, regulation, notification, custom or usage having the force of law in the territory of India, or any other instrument, treaty or agreement as envisaged under Article 363 or otherwise. Part 22, Art. 393 to 395 Short title, Commencement, Authoritative text in Hindi and repeals 5. Schedules of Indian Constitution. The Constitution of India at the time of its adoption had only 8 schedules, to which 4 more were added during the succeeding 65 years. First schedule 28 states and 8 union territories with territorial demarcations. Second schedule Part A salary and emoluments of the President and Governors of the states. Part B, Part C omitted salary and emoluments of the Speaker, Deputy Speaker or Chairman with Chairman of the Lok Sabha, Rajya Sabha and state legislative assemblies or councils. 630.1 Knowledge. Part D salary and emoluments of the Judge of the Supreme Court and High Courts. Part E salary and emoluments of the Control and Auditor General of India. 3 Schedule forms of oath and affirmations of members of legislatures, ministers and judges. 4th Schedule allocation of seats to states and uni territories in the Rajya Sabha. 5th Schedule administration and control of scheduled areas and STS. 6th Schedule administration of tribal areas of non-eastern states. 8th Schedule distribution of power between the union and the state government, union list, style list and concurrent list. 8th Schedule description of 22 languages recognized by the Constitution. 9th Schedule validation of certain acts and regulations. 10th Schedule provisions as to disqualification on ground of defection, anti-defection law introduced by the 52nd Constitutional Amendment Act. This schedule followed latest development by 91 Amendment to the Constitution in 2003. 11th Schedule powers, authority and responsibilities of panchayats, 29 subjects over which the panchayats have jurisdiction, refer to the 73 Constitutional Amendment Act. 12th Schedule powers, authority and responsibilities of municipalities, 18 subjects over which the municipalities have jurisdiction, refer to the 74th Constitutional Amendment Act. 6. Special features of Indian Constitution. The Constitution of India is the lengthiest and the most comprehensive of all the written constitutions of the world. Originally, the Constitution of India consisted of 395 articles divided into 22 parts and 8 schedules. Unlike the federal constitutions of the USA and Australia, the Indian Constitution lays down provisions relating to the governmental machinery not only in the centre but also in the states. The Indian Constitution provides for matters administrative detail. The Constitution contains detailed provisions relating to center-state relations, including the emergency provisions. Special status has been given to Jammu and Kashmir and some other states such as Nagaland, Mizoram, Assam, Gujarat, etc. Under the Constitution, the people of India are the ultimate sovereign. Number of articles. Due to the exercise of adding and subtracting the insertion and repeals of various articles clauses made by the amendments to the Constitution, the confusion dilemma about the number of articles has prevailed. But the charm made by the amendments were named clauses of some articles and not separate articles. Hence, technically there are only 3 articles in the Constitution of India. 631. Indian polity. At the Constitution of India establishes a parliamentary form of government both at the centre and in the states. The Indian Constitution, though written, is sufficiently decisive. The Constitution declares certain fundamental rights of the individual. It is a unique feature of the Indian Constitution that it makes the citizens' duties a part of the basic law of the land. One of the most important and unique features of the Indian Constitution is the provisions of directive principles of state policy to secure a truly welfare state. The Indian Constitution distributes the legislative subjects on which the Parliament and state legislature can enact laws under 3 lists, viz. Union list, state list and concurrent list. The Indian Constitution, unlike other federal constitutions, provides for a single unified judiciary with the Supreme Court at the apex, the high courts in the middle and the subordinate courts at the bottom. There are provisions in the Constitution to ensure independence of judiciary. The Constitution of India has adopted a balance between the American system of judicial supremacy and the British principle of parliamentary supremacy. The most remarkable feature of the Indian Constitution is that being a federal constitution, it acquires a unitary character during the time of emergency. Under the Indian Constitution, every adult above 18 years of age has been given the right to elect representatives for the legislature without prescribing any qualification based either on sex, property, education or the like. It is a distinctive feature of the Indian Constitution is that it provides for the establishment of a secular state regardless of their religious beliefs. All Indian citizens enjoy equal rights. The state cannot discriminate against anyone on the ground of religion or caste, nor can it compel anybody to pay taxes for the support of any particular religion. The Indian Constitution has special reservation of seats for the scheduled castes and tribes in public appointments and in educational institutions and in the union and state legislatures. An outstanding feature of the Constitution is Panchayati Raj. The idea for organizing village panchayats was provided in the Constitution under Article 40 of Part 4, which received constitutional legitimacy through the 73rd Amendment to the Indian Constitution. 7 Federal and unitary features of the Indian Union. India is different from the United States of America because in United States the federation is based on an agreement between different states and the states have the right to secede from the Union. The Indian Constitution has the features both of a federal and unitary forms of government. Federal features distribution of powers between Union and the states has been made as per the 3 lists. A632. The Union government as well as the state governments have to function strictly in accord with the Constitution. They can neither after the distribution of powers for override the dictates of the Constitution. Indian Constitution is entirely written. An amendment to it must be passed by the Parliament, and if an amendment affects the federal structure, it must be ratified by at least half the state legislatures. Like other federal states, our country also has an independent judiciary as an essential feature. Unitary features of the Indian Constitution. In its duration, people enjoy dual citizenship, that of the centre and of the state to which they belong, but the Indian Constitution provides every Indian with single citizenship. The most important subjects are included in the Union list which has been allocated to the centre. The center can legislate on the subjects in the concurrent list. Residuary powers belong to the center. Single constitutional from code has been provided for the center as well as for the state. The proclamation of national emergency can immediately turn the federal system of India into a unitary one. In a federation, each statehood get equal representation irrespective of its size or population. But in the Rajya Sabha in India, states are represented on the basis of population. Besides, the president has the power to nominate 12 members to the Rajya Sabha. The governors of the states are appointed by the president and they continue to hold office only during his pleasure. The Indian constitution provides for single judiciary, a single system of civil and criminal law and command all India services. The authority of the controller and auditor general and the chief election commissioner uniformly prevails over the union as well as states. 8. The preamble. The preamble to the constitution states the object which the Constitution seeks to establish and promote, and also aids the legal interpretation of the Constitution. Where the language is found ambiguous, the ideals embodied in the objectives resolution is faithfully reflected in the preamble to the Constitution which, as amended in 1976, summarize the aims and objects of the Constitution. Text of the preamble. He the appel of Fodia having solemnly resolved to constitute India into a democratic Ranbir and to secure to all citizens justice, social, economic and political liberty of thought, expression, belief, fight and won be equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our comment as on this 26th day of November, 1949, do headstone act and give his ourselves that constitution. 633. The preamble specifies the source of authority, people of India, the system of government, the objectives to be attained by the political system and the date of adaptation and enactment of the constitution. Though the preamble is not enforceable in a court of law, it provides a key to the understanding and interpretation of the constitution. In case of doubt, the Supreme Court has referred to the preamble to elucidate vague aspects of the Constitution. In the Berubari case, the Supreme Court held that the preamble was not part of the Constitution, but later in the Keshwananda Bharti case, it declared that it was part of the Constitution. 9. Lapse of paramountcy. When the Indian Independence Act 1947 was passed, it declared the lapse of suzerainty, paramountcy, of the Crown in Sec 7, 1b, of the Act. As from the appointed day the suzerainty of His Majesty over the Indian states lapses, and with it, all treaties and agreements in force at the date of the passing of this act between His Majesty and the rulers of Indian states, all functions exercisable by His Majesty at the date with respect to Indian states, all obligations of His Majesty existing at that date towards Indian states or the rulers thereof, and all powers, rights, authority, or jurisdiction exercisable by His Majesty at that date, in or in relation to Indian states by treaty, grant, usage, sufferance or otherwise, of the states situated within the geographical boundaries of the Dominion of India, all, numbering 552, save Hyderabad, Kashmir, Bahawalpur, Junagadh and the NWF, Northwest Frontier, states, Chitral, Fulra, Dir Swat and Amd, had acceded to the Dominion of India by the 15th August 1947, lay, before the appointed day itself. 10. Integration and merger of Indian states. Sardar Vallabhbhai Patel and V.P. Menon played the most important role in the integration and merger of Indian states. The main objective of shaping the Indian states into sizable or viable administrative units was sought to be achieved by a threefold process of integration, known as the Pater scheme. After Sardar Vallabhbhai Patel, Minister in charge of Home Affairs, 216 states were merged into respective provinces, geographically contiguous, connected to them. These merged states were included in the territories of the states in Part B in the first schedule of the Constitution. The process of merger started with the merger of Odisha and Chhattisgarh states with the then province of Odisha on 1 January 1948. 261 states were converted into centrally administered areas and included in Part C of the first schedule of the Constitution. 3. The third form of integration was the consolidation of groups of states into new viable units, known as Union of States.